So today's Cardinal Lesson, we're going to be sharing with you the top IRA rulings in 2024. And that doesn't sound like all that exciting, and it probably isn't to a lot of you. But to us financial planning nerds, this is a big deal. 2019, they passed the Secure Act, Congress did. The President signed it, and it started in 2020. And we're still talking about it in 2025, and we're still unsure about a few things. But a lot of them got cleared up by these rulings in 2024. So we're going to be going over the most impactful of those today with you. So I want to bring Tom on, and I want Tom to talk about why are we talking about top IRA rulings in 2024 today.
Yeah, I mean, at the end of the day, an IRA is really just an IOU to the IRS. It was never intended to be a good estate planning tool. It was never meant to be passed on as the primary way to pass on legacy to the next generation. But most of you is how you use that, right? Most of you, that's where your savings is. That's what you view as going on to the next generation. And the Secure Act and then the Secure 2.0 Act really made it even worse, right? It never was intended, and now it's much worse. But it's complicated rules. There's a lot of complicated rules that are around it. You start reading through the Secure Act, the Secure 2.0, trying to figure out what it all means is hard, to the point that when we read it, when us and other professionals read it, it was still unclear. And that's why they needed to have these rulings and these clarifications and stuff. And so what we wanted to go through today is, again, like Hans mentioned, go through the key points that they've clarified in the rules, explain how that works for you, what it means for you, and then really talk about what you should be doing from a planning standpoint to set things up in a better way for you and your family. And so let me bring up the show notes here. You can find these at the link below our video. They're also on our website at cardinalguide.com. We have the board as always, and then we have sort of a nice sort of a summary of the different rules that were clarified. All of these aren't represented on the board. We've just pulled out sort of 5 of the most impactful ones for our clients. But again, there are more things in there. So if you read through this and have some questions, you can just reach out and we'll provide some guidance here. So let me turn it back to Hans, and we'll just get going on the board here.
So let's talk about the Secure Act, like what it did and why we have it and what effect that it's had on you and your business. The biggest effect of the Secure Act was to get more tax out of beneficiaries of IRAs. Okay, what was going on before 2020 is anyone that inherited an IRA could then stretch the distributions out over their lifetime. And so it just left a lot of the 30 trillion plus that's in IRAs and 401ks and other retirement plans stuck there untaxed. And so the government wanted to start taxing these beneficiaries. At the same time, it wrote some provisions to protect certain classes of beneficiaries. So it came out in 2019, started in 2020 for deaths at 2020 and after. And then there was Secure Act 2.0, which was trying to fix some misunderstandings and it added a few things, changed a few things. That was in 2022. And then in 2024, we got the final Secure Act regulations from the IRS that goes over the whole thing and the whole package. So what we've done is we've picked out 5 of those that we think are the most important to go over in this video. And the first one is, this is an area that people don't really understand. And it's just, if you're a non-spouse beneficiary and you don't fall under one of these categories for the eligible designated beneficiary, you're going to fall into the 10-year rule. And everybody pretty much understood that 2020 and after. Or if you didn't understand that, you'd inherit the IRA, somebody would tell you, or you'd read, you got 10 years to empty the IRA. That's the 10-year rule, is that you can just leave it alone and you can just wait till the end of the 10th year. And at the very end of the 10th year, you got to pull it all out and pay the taxes, which that sounds pretty good to somebody that just inherited the money, that doesn't need the money, just to leave it in their tax deferred until that year. The problem with it is it's going to create a very big tax hit in that 10th year. And so for people who do need the money, they're not going to pay any attention because you can take all you want whenever you want as soon as the person dies. So if you want to take it all out in the first year, go for it. And people that really desperately need the money or just kind of need the money, they don't mind paying the taxes because they didn't work for the money. So that's going to be something a number of beneficiaries do. But if everybody was doing that, the IRS wouldn't have needed the Secure Act. So I'm going to explain to you how it actually works, because what they had in the language of the Secure Act, and then they further clarified in the Secure Act 2.0, was an extra provision, the at least as rapidly rule. And what it said is if the person who died, the account owner who's deceased, had already started RMDs, which means they were 73 or older, if they had already started RMDs, you, the inherited IRA beneficiary, must continue to take RMDs in year 1, 2, 3, 4, 5, 6, 7, 8, 9. You got to take what is a smallish RMD. And then in year 10, you got to empty whatever's left. So that is the marrying of the at least as rapidly rule and the 10-year rule. So I want to bring Tom on because I'm just rattling off provisions here, and I want Tom to explain what that means.
Yeah, I mean that's exactly right. I mean, there was a lot of confusion when this got put in the law because a lot of people, and the way it read initially, it's like, okay, we have 10 years, we can wait 10 years, and then the account has to be emptied, and we don't have to worry about RMDs along the way. And then the IRS came back and said, no, wait a minute, that's not exactly right, and that's where this at least as rapidly rule comes in. A really good way just to think about it, just to simplify it, is if RMDs have already started for who the original owner, if you inherit it, you have to continue the RMDs. Now, it's based off your life. There's different calculations. Don't try to do that on your own because it gets complicated. But if they've already started, they have to continue. That's really what it says. Now, from a planning standpoint, that's probably not the best strategy, right? If you're only taking the minimum out for years 1 through 9, that's a small amount coming out. The account might be growing more than what you're pulling out. So now the balance is growing even more. We get to the end of the 10th year, we got to take the whole account out, and now we have a huge tax bill there. So we just pushed off the problem. And so in reality, you probably need to be taking more than the minimum anyways, trying to evenly spread that over a 10-year period of time so we don't have any big spikes in income in any given year. But what the rule says is you have to take a minimum amount out based off your life expectancy when you inherited this account, assuming the original owner was already taking RMDs. You got to do that for the 9 years. The 10th year, it's got to come out.
Yeah. So they've just put the two together. So now you've got two criteria. If you're a beneficiary of an IRA, and we have a lot of them call us because they've watched our other videos about inherited IRAs. And, we work in 50 states in the District of Columbia. People are watching these videos, so they call us. And most of them don't have a clue, like, what do I do? And the first thing we want to ask them is, like, do you need some of the money? Do you want some of the money? Or is it better for you to delay taking it and get some tax advantages? So the first thing, we got to get some questions answered around their needs. And then as we get into that, we can start to come up with an optimal strategy for distributions, because there's no rule that you have to just take the minimum. The minimum is just what it said. It's a minimum. It says you have to take this much. You can take more. And so a good strategy for a lot of people is just to even it out and take 10% a year for 10 years plus interest. And we even have some ways to set up an annuity that'll just send you a check, and you'll meet all of this stuff, and you'll just get a check every month for the 10 years. Okay, that's kind of a simple solution that some people opt for. But in any case, years 2021, 2022, 2023, and 2024, this RMD under the at least as rapidly rule was waived. So along with providing clarification in July of 2024, they said, we're not going to penalize people who didn't take an RMD in 2021, 2022, 2023, and 2024 But in 2025, which is now, you got to take one. And then you got to do it for the rest of through the 9th year, whatever would be the 9th year. And then you got to empty the thing in the 10th year. So again, we could put together a strategy where you'll comply with all this stuff. And then secondly, the strategy will meet your needs. I mean, I had a lady come into me who is still working and she's got a pretty high income. She's going to retire in 2 years. And her father died in like 2021. So she didn't take anything for 21, 22, 23, 24. And she really would like to take nothing for 2025 and 2026 because she is still working and she's going to get a lot of tax. But then she'd like to empty the thing over 27, 28, and 29. I don't know, in 2030, I can't remember the exact amounts, but then we evenly spread it over that when she's presumably going to be in a lower tax bracket. We can put all that stuff together for you and put a little plan together. So just the net result, this is the biggest thing that came out in 2024 is clarification around that. And that doesn't mean that it's the best strategy. This is just the minimum that you got to meet to avoid being penalized.
I'm gonna add one more thing on that front. And so one thing that comes up is with Roth IRAs. So let's say the original owner had done some Roth conversions, they had converted it all to a Roth, and now they pass away and you're inheriting a Roth IRA. One, that's very beneficial for you, right? There is no tax owed on that. But the question becomes, can I leave it in the Roth? And I like this growing tax-free. And so it's still subject to that same 10-year rule, right? It has to be emptied by the end of the 10th year. So you could keep it in there for 10 more years and then pull it out, but it still has to come out. But more importantly is thinking about this least and rapidly rule. I guess a question for you would be, and I'm going to answer myself, but do Roth IRAs have RMDs? Like when I said, once RMDs start, they don't stop, right? You have to continue them. Well, do Roth IRAs have RMDs? And the answer to that is no. And so if you are the owner of a Roth IRA, you don't have any RMDs. So there is no beginning date. There is no start to RMDs during your life. When you leave that to the next generation, they don't have any RMDs because it never started for you. So the only rule that you're worrying about now with a Roth IRA is that 10-year rule. And it still has to be emptied by the end of the 10th year. But if you're inheriting a Roth and you don't need the money, it's probably better just to leave it in there for the remainder of that 10 years, get 10 more years of tax-free growth, and then pull it out at the end. So that's just something to consider.
Yeah, a Roth is a perfect thing to leave to your kids. I mean, it's just because they're going to inherit it. They're not going to owe any taxes on it. And then if they're able, they can leave it there for 10 more years growing tax-free and then pull it out tax-free at the end of the 10th year. I mean, that's a very nice thing to leave to your kids. Okay, the next thing they did is, well, actually in the beginning of the Secure Act, they created this category called an eligible designated beneficiary. And what that is there's certain people, certain classes of people that they allow to still stretch the IRAs, the distributions out over their lifetime, pre-2020 stretch. And those are minor children, surviving spouse, disabled, chronically ill, and a person not more than 10 years younger, person about the same age. So those 5 categories of people can still stretch. And what they did with those under the 2024 ruling is they eased some of the definitions. So they made it a little bit, and specifically with disability, there was, in the original Secure Act, there was a very strict definition of disability, or in the initial regulations from the IRS, they put a strict definition of disability, and that has been liberalized quite a bit so that now if you're desiring to, you can qualify under that as a beneficiary. So we can talk to you about that a little more if need be. So the categories are the same, they just ease the definitions. Tom, you want to speak to that?
Yeah, I mean, the main area is really around the disabled beneficiary, right? Who qualifies for that? And like Hans mentioned, they just sort of eased the rules. Initially, it was a very strict definition. Now it's a little bit more liberal in terms of what they will qualify as that. And so again, if that is you, or if you know someone who's in that situation, who's inheriting an IRA, call us so we can sort of walk you through that, what that allows them to do. But at the end of the day, what an eligible designated beneficiary is able to do is stretch out that IRA for the remainder of their life, as opposed to being subject to the 10-year rule. So they're kind of like under the old rules that were on IRAs. So it gives them just a little bit more ability to keep that money in the account, stretch it over a longer period of time, not having as much tax impact there. Which again, if you are disabled and maybe you're on Medicaid or SSI or something like that, that becomes important, because income from that could really upend your benefits that you're receiving, or your family, if you have a family member who's going through this, what they could receive. And so at the end of the day, if someone is receiving state benefits like that, IRA money probably should never be left to them in the first place. But that gets missed a lot of times. So again, this at least gives them a little bit more flexibility on how they handle that.
Okay. So the third one we're talking about is if people own multiple IRAs. You may or may not be aware, you can take all of your RMD, or required minimum distribution, out of one of the IRAs. You can aggregate the RMDs from all of the IRAs and just pull it out of one, whichever one makes sense to you. But if you're doing that, they just clarified, if you're doing that, you must do all that before you do any Roth conversion. So you can't do it out of just one. You got to take the whole aggregate RMD out before you do any conversions. So the fourth one, we're talking about surviving spouses. This is big, especially if you have a person who passes away relatively young by our terms. Somebody passes away in their early 70s, late 60s, and they have a younger spouse, or a spouse the same age, is that with the younger spouse, that surviving spouse can leave this as an inherited IRA and not take the RMDs until they reach 73, as opposed to under the old rules, they had to start taking the RMD if they left it as an inherited IRA whenever the deceased would have turned 73, or if they've already started them, they had to keep taking them. So they just clarified that it's favorable for surviving spouses. And we can do some planning around that, tell you what would be best. We've done that for several clients. And then the fifth point, the RMD shortfalls. So we, throughout our career, have run into a number of people, and sometimes they're the children of these people that are in their late 70s or their 80s, and we find people that have maybe never taken an RMD. They've just slept right through those, never taken them, and they're usually no consequences have fallen on them. There's not really the RMD police out there from the IRS that's coming and looking for those things. So, and some of these same people have not filed tax returns. We've had several of those sent to us where they have dementia. They've just developed it over a period of years, and they just were managing their own stuff and not doing it very well. So what they clarified, again, in July of 2024, is the 3-year statute of limitations on RMDs. So as long as there's no fraud involved or attempted fraud, we only have to go back 3 years, or a little longer than 3 years, or there's a 3-year statute of limitations on, because some of these we've had to go back, like 10, 11, 12 years and calculate all that. It's quite a bit of a mess. So there's a 3-year statute of limitations so we can just go back and account for 3 years. And we've helped a number of people out of that situation. And then you can file an appeal to the IRS to get out of the penalties if there was just cause. Those are sometimes successful, sometimes not. But a lot of times when people are in this situation, they just want to be rid of the problem. The daughter or son will discover this, and it really causes a lot of problems to do this and file old tax returns. And we have people that can help with all of that. So these are really the 5 biggest, we picked out of a list. In the show notes, it's got about 11 or 12 most relevant, I would say, rulings of 2024. So I want to check the boxes here in our comprehensive financial planning, and I want to work backwards, because this whole video has been about limiting or managing taxes, because it just, when this is left without being planned, distributions out of your IRA, whether they're during your lifetime or you just postpone them as best you can, and then you pass away and it gets put on your kids, it's creating the proverbial tax bomb that a whole bunch of pent up taxes that all come due in 1 year over a distribution. Estate planning is an IRA is not really a very good tool to use to transfer wealth. It wasn't really intended that way. If that's your intent with your IRA money, we can set up perhaps a life insurance policy. If you're young enough, if you're in your 70s, early 70s, or late 60s, or somewhere in your 60s, maybe even in your mid 70s, we could set up something like your RMD to pay the premium on a life insurance policy that will go tax-free to your kids. We can set up a Roth IRA or Roth IRA conversion strategy for the part that goes to your kids to really deal with the taxes at estate time. Income is, we're really talking about income over 10 years in most cases, and we can set that up. We had a fellow that inherited about $7.5 million from his sister, so he qualified under this thing, the not more than 10 years younger, so he could stretch it over his lifetime, which took him from like 67 to 86. And then we set up annuity payments that will meet all of this stuff. He's just getting a check every month till he's 86. If he dies before 86, his heirs will just inherit those checks and they'll keep coming in. And most important thing is he's met all of this and he doesn't need to think about it every year. This whole show has been about IRA rulings. And what I want to mention with long-term care is if you have inherited an IRA and you're under the 10-year rule, and whether you're under the at least as rapidly or not, we actually have a company that will sell you a long-term care life insurance policy that the premium can initially be paid out of an IRA, and then it can be paid over 10 years, the premium for the life long-term care policy. Another show, another time, but it might be an opportunity for you to buy and pay for long-term care insurance for you and your spouse. We've done that for several people. So I want to bring Tom back on. I'm Hans Scheil.
And I'm Tom Griffith.
We thank you very much for listening.
Thank you.